Hello, I'm ISBA President Paula Holderman. My guest today is the Honorable Thomas Mulroy, an Associate Judge in the Circuit Court of Cook County. I spoke to Judge Mulroy about the proposed mandatory arbitration program in the Law Division and the benefits it will have for both litigants and lawyers. Judge Mulroy, thank you very much for being here today. Can you tell me about the proposal that you and others have put together for a new mandatory arbitration in the Law Division?
Thank you, Paul. This is a great opportunity for me to talk about this. I really appreciate it. One of the issues that we have in Cook County, maybe more than other counties, is it's very difficult to get a small case, $75,000 or less in this situation, to a full and fair hearing. Most lawyers and most litigants can't afford it. So the idea behind this program is to provide an experienced arbitrator to listen to these $75,000 or less cases. And the genesis of the program is we were having a meeting. This program only applies to commercial cases, not to injury cases, not to divorce cases, just commercial cases. And there are only 9 judges in the commercial calendar, is what they call it. We were having a meeting with Judge Maddox, who suggested that we institute a program of mandatory arbitration for smaller cases. And I complained about it to him. And I said, you know, Judge, I don't think that we need this. We have a very speedy turnover of cases. Most cases only last from beginning to end in the commercial division a year and a half, which is fast. And of course, so many of them settle. And after I finished my peroration, he said, well, that's good, Judge Mulroy. You should be the committee chairman of this group in order to decide whether we should do it. And after I investigated it, I realized what a great idea it was. The first thing I did was put together a group of commercial lawyers who specialize primarily in commercial litigation to advise the judges on what this program should look like. We came up with a program which has a single arbitrator, which is a speedy program. Your case will go to arbitration 4 months after the answer has been filed. And the arbitrator will have 30 days to resolve it. I don't mean that the hearing goes 30 days. The hearing will only be 4 hours, 8 if it's a very complex case, which would be unusual for a $75,000 case.
So that time limit is built in to the proposal right now?
That's built in. And then the arbitrator needs or will issue his award or her award within 24 hours after the close of the proofs. The proposal is now with the Illinois Supreme Court, and if it's approved by the Illinois Supreme Court, it'll go to the Rules Committee.
Okay. And one of the concerns, Judge, that I have heard from practitioners is about the 24-hour period that the arbitrator has to make the decision. Could you comment on that?
That's a great question. I've heard the same thing. And remember, the details of the program are still kind of a work in progress, and that's one of them. A lot of lawyers, and by the way, just as an aside, I've gotten an awful lot of interest from lawyers, commercial practitioners, who want to be arbitrators in these cases, which is a good thing. We wanted the decision to be made as close to the close of the proofs as possible, because this program is supposed to be a mix of mediation and arbitration. Every time the parties come together in a small case, it's an opportunity to settle. And so we thought at the close of the proofs and before the ruling, if the parties knew there was going to be a ruling in 24 hours, they would be more likely to have it on their radar screen, to sit down and see if they couldn't settle their $70,000 case before the award came out. But if the public comment shows that people don't think that that's too short of a time, it's easy for us to extend it to 2 or 3 days. The award won't be a written reasoned award. It'll be just a check. You check a box and put in a number.
And now, Judge, I think you mentioned in terms of the process, you, of course, worked with your committee and put together the proposal. Where is the proposal now? What are the next steps?
We completed drafting the proposal and gave it to the presiding judge, Bill Maddox, who heartily endorsed it. and he took it to Chief Judge Tim Evans, who added some things and did a very careful review of it, and he sent it to the Illinois Supreme Court, and that's where it is now. We're waiting for their review.
Very good. Thanks, Judge Mulroy, for being here today to discuss the proposal for a new mandatory arbitration program in the Law Division. I'm Paula Holderman. Thanks for watching. See you next time.